make a start. Thank you everybody for coming on this lovely sunny day. This is the final of the Mooting competition. This competition has been running throughout the year, the whole academic year. We've had lots of different heats, lots of rounds, and we're now at the stage of the final. I know both these teams very well. I wish you both the best of luck. And I honestly can't call it because I think they're both extremely strong. So this promises to be a very, very good moot final. No pressure. No. The winner of the event will have their name engraved on this beautiful trophy. It's the first time we've ever had a trophy like this. It's the William Rommel Mooting Cup. And your names will be engraved on that. And you'll be the first names to be on here because it's new. And then every year going forwards, we're going to engrave the winners' names on this cup. You will all get a certificate because you're all finalists. But also there is a cash prize. Do you know what the cash prize is? No. Do you know? The winners get £75 each, and the runners-up get £25 each.
That's what we win either way.
So there's drinking money to be had either way. So all I can say is all the best.
Let's go home now.
I don't actually have the cash on me now, so you have to wait for it. Don't charge me interest. There is a camera here because I just thought, because it is a moot final, I think we should video it for future students and reference. So just forget the camera's there, just look at the judge. Okay, I'm just speaking to her, she's very lovely. Okay, so remember, deep breaths, speak nice and slowly, yeah? Okay, so I'm going to introduce you to our judge now. So would you care to all rise?
Good afternoon, everybody. If you'd like to be seated. Just give me a minute to get myself comfortable and get my papers together. So this is the case of Mr. Smith against PCP Limited. You ladies must be acting for the appellant in this matter, am I right? Perhaps you'd like to introduce yourselves to me then.
Good afternoon, Your Ladyship, Counsel. May it please Your Ladyship, my name is Miss Platt and I appear on behalf of the appellant, Mr. Smith, with Miss my learned junior, Miss Boardman.
Miss?
Boardman.
Right. Afternoon, Miss Platt. Afternoon, Miss Boardman.
Okay.
And then for the respondent to this matter we have?
Yep. Good afternoon, Your Ladyship. My name is Ellen Rutherford. I'm Senior Counsel for the Respondent PCP Limited in this matter, and I should be assisted this afternoon by my learned junior, Miss McAllister.
Right, so Miss Rutherford and Miss McAllister. Afternoon, ladies. Right, as is customary in these matters, excuse me, everyone, we impose a time limitation of 15 minutes per advocate. Were you familiar with that? You aware of that? That's fine. Obviously, I'll hear from you both first, followed by the respondents to this matter. If there are any matters arising that you wish briefly to make comment on, I'll give you opportunity to do so, but obviously you're not required. So if you'd like to commence.
We'll be doing now.
Thank you. So, just briefly, I have in here judgment from the lower court, yep, followed by skeleton argument, and then what else have you got in here for me?
There are our authorities for our submissions today, Your Ladyship.
Okay. Right, thank you. Would you like to get started?
Your Ladyship, the ground of the appeal in today's matter is that the learned judge, His Honour Judge Jones, erred in his decision to dismiss the appellant's claim. It is the appellant's submission that the relevant statements were not incorporated as terms of the contract between the appellant and the respondent.
Right, okay. Not incorporated. Yep. Would you like to continue?
In the appellant's submission today, I will refer Your Ladyship to the cases of J. Spurling Limited and Bradshaw, reported in Volume 1 of the Weekly Law Reports for 1956, starting at page 461.
Right, and that's in the bundle at what page?
It is tab, pink tab 1, Your Ladyship.
Right,
Do you
tab one.
require a summary of this case, Your Ladyship?
When you get to the point where you're asking me to consider it, give me a brief overview.
Okay, sure. I'll also refer Your Ladyship to the case of Thornton and Shoe Lane Parking, reported in Volume 2 of the Queen's Bench Division
Okay.
for 1971, starting at page 163. Would Your Ladyship require a summary of the case before us today?
And where's that? Is that in the bundle at tab?
That is tab 3, Your Ladyship.
Tab
I
3.
think tab 3.
Get started on your submission, and when it becomes relevant, give me a brief overview of these cases to go along.
Your Ladyship, the respondent will seek to convince you that the statements were incorporated as terms of the contract.
Right, both.
It is the appellant's submission that this is not the case, and that the statements were not effectively incorporated as terms of the contract, as the respondent did not do what was reasonable to sufficiently bring them to the notice of the appellant.
Right. Okay.
Furthermore, the respondent attempted to incorporate the terms after the contract had already been formed.
Right, I was going to ask you that. So when do you say that the contract was formed?
Your Ladyship, from the facts of the matter today, it is the appellant's submission that the contract was formed on entry of the car park.
Right.
The terms were then incorporated following entry.
So contract formed on entry.
Firstly, it's the appellant's submission that the map present before us today differentiates that of J. Sperling Limited and Bradshaw.
Okay. So run me through that one, Sperling and Bradshaw.
The defendant, who had previous business dealings with the plaintiff, delivered to them 8 barrels of orange juice for storage, and a few days later received a landing account which on its face referred to conditions printed in small type on the back. These included the London Literature Clause, which exempted the plaintiffs from liability for any loss, damage or detention in respect of goods entrusted to them in the course of their business.
I remember that one now.
Your Ladyship, if I refer you to page 467 of the said case, that is pink tab 1.
Just going to have to pause for 1 second. Could you give me an eye on timing? Because otherwise my phone's going to go. Thank you. So tell me the page number again.
It is pink tab 1 and that is page 467.
1467. Yep, got it.
Lord Denning's judgment states that Mr Bradshaw admitted that he had received many landing accounts before and went on paying the warehouse rent for months afterwards. It seems to me that by the course of business and conduct of the parties, these conditions were part of the contract. It's therefore the appellant's submission that for a previous course of dealings to incorporate a term, there must have been a sufficient number of dealings. This principle has also been established in the case of Hardwick Game and Suffolk Agricultural Poultry Producers Association, also abbreviated as SAPPA, which is reported in Volume 2 of the Appeals Cases for 1969, beginning at page 31. That is pink tab 2, Your Ladyship. Do you require a summary of this?
No, recall that one.
Your Ladyship, if I may refer you to page 113 of the said case, which is pink tab 2.
Yeah, you've helpfully highlighted it for me.
Lord Pearce stated that SAPPA had regularly received more than 100 similar contract notes from Grimsdale in the course of dealings over 3 years. They knew of the existence of the conditions on the back of the contract notes.
Sorry, just stop you there. Are you saying there wasn't a course of a previous course of dealings,
Yes,
or just not sufficient?
Your Ladyship, it is the appellant's submission that there wasn't a sufficient number of dealings, as there was only 10 dealings the previous year.
Right, so there had been a previous relationship and course of dealings,
There had,
but you say
yes.
10 occasions isn't sufficient.
Yes, Your Ladyship.
Okay, if you'd like to continue.
If I may also refer you to page 104 of the same case, which is pink tab 3, Your Ladyship.
through. Tell me the page number.
It is page 104.
Yeah, there we go. Okay.
Lord Guest refers to Lord Devlin's judgment in the case of McCutcheon and David McBrain Limited, which was reported in volume 1 of the Law Reports for 1964, beginning at page 134. It was stated that if previous dealings show that a man knew of and agreed to a term on 99 occasions, there is a basis of saying that it can be imported into the 100th contract without an express statement. As previously stated, Your Ladyship, it is therefore submitted that a mere 10 dealings the previous year is not enough to bind the appellant to the exemption clause. Furthermore, Your Ladyship, in distinguishing the instant case from that of J. Sperling Limited and Bradshaw, it is the appellant's submission that the clause was not only incorporated after the contract was made, but also printed and placed in such a way that a reasonable man might miss it. Therefore, Your Ladyship, the appellant submits that he cannot be bound by the exemption clause and the respondent is unable to rely on the same. Your Ladyship, if I may refer you to 468 of J. Sperling Limited and Bradshaw, which is pink tab 4.
Yep.
A judgment of Judge Ballack is quoted from the case of Rowe and R.A. Naylor Limited, reported in volume 1 of the King's Bench Division for 1917, starting at page 712. Therefore, the question in the present case is whether this printed clause is a clause which is so printed that from its position in the document and the size of the type, an ordinary careful businessman reading the document with reasonable care might miss it. The appellant submits that this question should be put before the matter before us today. Your Ladyship, the terms were placed on the 3rd floor of the car park at the bottom of the notice board in very small letters. It is submitted that these terms were placed and printed in such a way that a reasonable man might miss them.
Well, a couple of questions. Multi-storey car park. Do we know where he parked?
Unfortunately, from the facts of the case, we do not have...
Well, I was looking through, I don't seem to see any finding of fact as to actually, on that occasion, on previous occasions, there's no findings as to where actually in the car park he parked. Okay. And do we know what was on this notice, apart from
We do, yes.
reported exemption clauses?
On the notice board, the clause is stated that PCP Limited excludes all liability for damage to car owner's property, howsoever caused, as well as liability for any economic losses.
And that's on the notice with the small,
That was on the
smaller
small
exemption
letters at the
clause
bottom
underneath.
of the notice board, Your Ladyship.
Yeah, what was on the what else was on the notice? What I'm trying to get at. Do we know?
The facts of today's case did not
Okay.
give us knowledge of that, Your Ladyship. The appellant also submits that the respondent did not take reasonable steps to draw these terms to the appellant's attention at the time the contract was made. Although there was a notice at the entrance of the car park stating that it is subject to their terms and conditions, and further the ticket stated that these terms and conditions can be found on the notice board on the 3rd floor of the car park, the appellant submits that these are not reasonable steps to draw such an onerous term to the appellant's attention. If I may refer Your Ladyship to the case of Ollie and Marlborough Court Limited, reported in volume 1 of the King's Bench Division for 1948, starting at page 532. Would Your Ladyship require a summary of the
Yeah,
case?
I'm not familiar with that one. And what tab's it at, sorry?
It's at pink tab 5, Your Ladyship.
Right.
A notice in the bedroom of a private residential hotel stated the proprietors will not hold themselves responsible for articles lost or stolen unless handed to the manageress for safe custody. It was held that the contract had been made before the guests could see it. It was held that the terms of the notice in the bedroom formed no part of the contract between the guests and the proprietors.
Right, and when had the contract been made?
The contract had been made on the guests arriving at the hotel and paying their rent in prior to their stay at the hotel. Your Ladyship, if I may refer you to page 533 of that case, that is pink tab 5.
Got it.
Lord Denning states, persons who rely on a contract to exempt themselves from their common law liability must prove that contract strictly. The best way of proving such a contract was by a written document signed by the party to be bound. Another way was by handing to him, before or at the time of the contract, a written notice specifying the terms and making it clear to him that the contract was on those terms. Nothing short of one of these three ways would suffice. If I may also refer you to page 549 of the same case, which is pink tab 6, Your Ladyship. Lord Denning further states that, as a rule, the guests do not see them until after he is accepted as a guest.
Yeah.
The hotel company no doubt hope that the guests will be bound by them, but the hope is vain unless they clearly show that he agreed to be bound by them, which is rarely the case. Your Ladyship, the appellant submits that the terms that the respondent wishes to rely on were only brought to the appellant's attention after the contract had already been made. It's also the appellant's submission that the respondent did not reasonably bring the terms to the appellant's attention, as the terms were situated on the 3rd floor of the car park and were placed at the bottom of the notice board in very small writing.
You said that the contract was formed upon entry, so presumably taking hold of that ticket from the machine.
The ticket was given to the appellant after entry to the car park. If I refer you to Thornton and Shoe Lane parking, Lord Denning states in that case, if I refer you to pink tab 8, Lord Justice McGaw.
Right, got it.
He states that I think it is a highly relevant factor in considering whether proper steps were taken fairly to bring that matter to the notice of the plaintiff, that the first attempt to bring his notice the intended inclusion of those conditions was at a time when, as a matter of hard reality, it would have been practically impossible for him to withdraw from his intended entry upon the premises for the purpose of leaving his car there. He further states, it does not take much imagination to picture the indignation of the defendants if their potential customers, having taken their tickets and observed the reference therein to contractual terms, which they said could have been seen in notices on the premises, were one after the other to get out of their cars, leaving the cars blocking the entrances to the garage in order to search for, find and peruse the notices. Your Ladyship, it is therefore the appellant's submission that the contract had been entered into prior to the appellant's notice to the conditions.
Okay.
Your Ladyship, in his judgment, in Lord Denning's judgment of Thornton and Shoe Lane parking, do you require a summary of the said case?
No, it's okay.
If I refer you to pink tab 7 at page 170, Lord Denning stated that the court should not hold any man bound by it unless it is drawn to his attention in the most explicit way. It is an instance of what I had in mind in J. Sperling Limited and Bradshaw. In order to give sufficient notice, it would need to be printed in red ink with a red hand pointing to it, or something equally startling.
Okay, thank you.
Your Ladyship, it is the appellant's submission, as previously stated, that the terms on the notice board were not sufficiently brought to the appellant's attention before entry into the car park, and that the terms were not incorporated before or at the time the contract had been made. Therefore, the appellant submits that the respondents were not contractually exempt from liability and cannot rely on the exemption clause.
Thank you.
If I may also refer you to page 164 of the case of Thornton and Shoe Lane parking. That is pink tab 9, Your Ladyship. Lord Denning states that The offer was contained in the notice at the entrance and was accepted when the plaintiff drove into the garage. The concluded contract could not be altered by anything printed on the ticket. He further states on page 166, that is pink tab 10, Your Ladyship. If, as in the present case, the ticket machine seeks to introduce conditions, an exclusion of liability at that stage is too late. Your Ladyship, is therefore the appellant's submission, as previously stated, that the contract was formed on entry to the car park and that any conditions thereafter could not be relied upon and were not incorporated into the contract.
What's the consideration?
Of the contract, the appellant paid the tariff of the car park in
Right.
order to stay, and therefore that it was an implied term that the respondent would take reasonable care.
But you say the contract was formed upon entry. Consideration was offered at a later date because he's not paying as he's going in, is he?
I'm afraid the facts of the case we're not aware of that, whether he pays in the automated machine there or at a later date.
Yeah, respondents may be able to help me with that. Okay, thank you.
If I may refer Your Ladyship also to page 169 of Lord Denning's judgment of Thornton and Shoe Lane parking. That
Yeah.
is pink tab 11.
Got it.
None of those cases has any application to a ticket which is issued by an automated machine. The customer pays his money and gets a ticket. He cannot refuse it. He cannot get his money back. He may protest to the machine, even swear at it, but it will remain unmoved. He is committed beyond recall. He is committed at the very moment when he puts the money into the machine. The contract was concluded at that time. Your Ladyship, this view should be applied in the facts before us today. The contract between the appellant and the respondent was concluded when the appellant drove into the car park. The contract could not be altered by anything printed on the ticket or the notice board on the third floor, and any conditions introduced at this stage is too late. Your Ladyship, in conclusion, it is a submission of the appellant that the respondent is unable to rely on the exclusion clause, and the appellant is not bound by the clause as the terms on the notice board on the third floor of the car park were not effectively incorporated as terms of the contract. If Your Ladyship is not persuaded on this point, my learned junior will now seek to convince Your Ladyship that even if it was found that the terms were indeed incorporated, they were not effective to exclude the respondent's liability or entitle them to charge £50 per day for late collection. Your Ladyship, that now concludes my submissions unless I can assist you further.
No, thank you, Ms Platt. So, Ms Boardman, you're going to make an alternative submission to the primary contention. Yeah?
Yes, Your Ladyship. I'd like to address you on the second point of appeal, which is namely that even if the terms of the contract were incorporated, they were not effective to exclude PCP's liability or to entitle it to charge £50 per day for late collection of Mr Smith's vehicle, which amounts to a penalty charge. The respondents obviously will seek to convince you otherwise.
No doubt.
Your Ladyship, in the appellant's submission today, I would like to refer you to the Unfair Contract Terms Act 1977,
Okay.
otherwise referred to as UCTA in short, and the Unfair Terms in Consumer Contracts Regulations 1999, otherwise known in short as the UTCCR.
Less familiar with those ones. Have you got a copy in the bundle?
There is, Your Ladyship, at Orange tab number 1 is a relevant section I'd like to draw your attention to, if I may.
These are the regs. Yeah, fire away.
That's section 5. At section 5, subsection 1, if I may quote, a contractual term which has not been individually negotiated shall be regarded as unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. And further at section 5.2, a term shall always be regarded as not having been individually negotiated, where it has been drafted in advance, and the consumer has therefore not been able to influence the substance of the term. Your Ladyship, in the case before you today, it's clear that neither of the terms that form the basis for this appeal were individually negotiated. Namely, and I quote from the facts of the case, that PCP Limited excludes all liability for damage to car owners' property, howsoever caused, as well as liability for economic losses, and that users of the car park will be charged up to £50 per day in addition to the usual tariff if they leave their car in the car park for more than 6 days. The appellant was not given any opportunity at any point to negotiate on any term that he would have been unhappy with. Also, Mr Smith was only presented with the ticket and allegedly informed about the existence of the terms and conditions and the notice board on the moment of his entry to the car park. Therefore, the terms must be regarded as not having been individually negotiated and as having been drafted in advance under section 5.2 of UTCCR as stated. Your Ladyship, referring then to section 5.1, again at the orange tab number 1, it can also be shown there is a significant imbalance in the rights of the parties, as PCP Limited have clearly sought to exclude themselves from any liability for damage to the appellant's car, in their words, howsoever caused. This indicates that PCP Limited appear to believe they're permitted to behave in a negligent manner towards the appellant's vehicle and therefore towards the maintenance of the car park without any repercussions to themselves. And surely this cannot be the case, Your Ladyship. PCP Limited have negligently maintained the car park's concrete pillars, resulting in the collapse of one of the pillars, which therefore went on to destroy the appellant's vehicle completely. This in fact was a custom-built vehicle which had cost in the sum of £500,000. This is clearly demonstrating an imbalance in the parties' rights and obligations as stated by the UTCCR, as the appellant cannot be reasonably accepted to write off such a large amount of loss without any repercussion on PCP Limited themselves. Your Ladyship, if I can refer you to Orange Tab 2, which is section 6.1 of the UTCCR 1999.
Okay.
And here it gives guidance as to the assessment of the unfair terms of a contract, and if I may quote from the statute, the unfairness of a contractual term shall be assessed, taking into account the nature of the goods or services for which the contract was concluded, and by referring at the time of conclusion of the contract to all the circumstances attending the conclusion of the contract and to all the other terms of the contract or of another contract on which it is dependent. Your Ladyship, I obviously invite you to make your own assessment of the terms and would respectfully suggest you do find them to be unfair to the appellant, given the reasoning I've put forward.
What was to stop him simply driving straight out again?
I'm not entirely sure on that point, Your Ladyship, but I believe he probably would have had to pay a sum to leave the car park. It's not entirely clear from the facts that we've been given.
So once he's in, he can't just turn around and go out again?
Exactly.
It's your understanding of the position?
That's my understanding of it, yes.
Okay.
Mr Smith, the appellant, he's entered the car park in good faith. Merely his intention was to safely and securely park his car for a period of time. At no point was he expecting to return to his car to find it completely destroyed.
No.
And he certainly didn't expect to have to pay the sum of £500 for the privilege of finding his car destroyed. Your Ladyship, it's section 8.1 of UTCCR, and that can be found at Orange Tab 3. An unfair term in a contract concluded with a consumer by a seller or supplier shall not be binding on the consumer. I therefore submit, Your Ladyship, that both the terms in dispute were indeed unfair, and as such can't have been binding on the appellant, and therefore PCP Limited are completely liable for the cost of replacing the appellant's vehicle, and again that being the sum of £500,000.
I'm assuming, I understand that these clauses are found online, and I know there's been a previous relationship between Mr Smith and PCP and that he's used the car parks before. I've made the assumption, perhaps you can tell me whether it's a safe assumption or not, that he's not booked online before.
We don't have any facts regarding the answer to that question, Your Ladyship.
Okay, there's nothing to suggest that he has in the judgment from the lower court, is there? Okay. And it's not an argument that was advanced by the respondent to the appeal at any stage?
Not that I'm aware of.
Okay, thank you. I'd like to continue.
Thank you. Your Ladyship, if I can draw your attention now to UCTA, the Unfair Contract Terms Act 1977, at section 1, subsections 1A to C, and this can be found at orange tabs 4 and 5 of the bundle.
Okay.
And if I may again quote from the stated sections of the Act, negligence means the breach A of any obligations arising from the express or implied terms of a contract to take reasonable care or exercise reasonable skill in the performance of the contract. B, of any common law duty to take reasonable care or exercise reasonable skill. And C, of the common duty of care imposed by the Occupiers Liability Act 1957. It can surely be said, Your Ladyship, that PCP Limited did have a duty of care towards ensuring that the appellant's vehicle was kept secure and safe whilst in their car park. Indeed, the Occupiers Liability Act 1957 imposes such a duty on them at sections 5.1 and section 5.2. Your Ladyship, that's at orange tab 7 in the bundle.
You're not relying on that though, are you? It's not the base of this appeal, is it? Or is
No,
it?
but I do feel it's relevant to draw the court's attention to
Right, okay.
this section.
So we're looking at,
It's orange tab 7.
right, I've got it.
Thank you. If I just quote from the Act, Your Ladyship, it's section 5.1, where persons enter or use or bring or send goods to any premises in exercise of a right conferred by contract with a person occupying or having control of the premises, the duty he owes them in respect of dangers due to the state of the premises or to things done or omitted to be done on them, insofar as the duty depends on the terms to be implied in the contract, by reason of its conferring that right, shall be the common duty of care. And at subsection 2, the foregoing subsection shall apply to fixed and movable structures as it applies to premises. Your Ladyship, it's clear from the wording of section 5.1 that it immediately draws your attention to the fact that PCP Limited did owe a duty of care towards the appellant and his vehicle in the car park.
Okay.
And the terrible state of the concrete pillars, it confers surely upon them that they did have a duty to maintain and repair the pillars as appropriate.
I don't think that's disputed. Is that disputed? Ms Rutherford?
It is not.
Not disputed?
No.
Thank you.
Thank you. Your Ladyship, so if I may just reiterate there, we do feel it is important to bring the court's attention to the fact that we do believe there was a breach of their duty of care under section 11C of UCTA 1977, conferred by the Occupiers Liability Act 1957.
Okay, yeah.
Your Ladyship, if I may now go on to state at section 2.2 of UCTA, that can be found orange tab 5.
Yep.
In the case of other loss or damage, a person cannot so exclude or restrict his liability for negligence, except insofar as the term or notice satisfies the requirements of reasonableness. Your Ladyship, obviously I now must draw your attention to the reasonableness test, which is given at section 11 of UCTA and stated at subsection 1. This can be found at orange tab 6 in the bundle.
Yep.
In relation to a contract term, the requirement of reasonableness for the purposes of this part of the Act is that the term shall have been a fair and reasonable one to be included, having regard to the circumstances which were, or ought reasonably to have been, known to or in the contemplation of the parties when the contract was made. Surely your ladyship cannot have been in the appellant's contemplation that he would return to find his vehicle completely destroyed.
Unlikely.
Also of significant relevance in the instant case is section 2.3 of UCTA. That's again at Orange tab 5, which states that where a contract term or notice purports to exclude or restrict liability for negligence, a person's agreement to or awareness of it is not of itself to be taken as indicating his voluntary acceptance of any risk. Therefore, your ladyship, the appellant's knowledge or lack of the existence of the exclusion clause cannot be taken under this Act as his acceptance of that clause, voluntarily or otherwise. And indeed, the case of Thornton and Shoe Lane parking, to which my learned senior has already referred, on page 170 of that judgment, Lord Denning did state that there was no evidence Mr Thornton knew of the exempting condition. He's not therefore bound by it. Therefore, in the present case before you today, no evidence has been provided that Mr Smith knew of the exempting condition either. Therefore, if we apply Lord Denning's judgment from Thornton, Mr Smith cannot have been bound by the exempting conditions either. Your ladyship, I would just like to briefly draw your attention to PCP Limited's attempt to include a penalty clause in the alleged parking contract. That being, they state they're entitled to charge up to £50 per day in addition to the usual tariff for a person to leave their car in the car park.
What do you mean penalty clause?
Your ladyship, if I can refer to the case of Dunlop Pneumatic Tyre Company and New Garage and Motor Company Limited, which can be found in the Appeal Cases Law Reports for 1914, beginning at page 79. I do have a judgment for you there, Orange tab 9.
Have a look at that.
This is at page 86, towards the top of the page in front of you. Sorry, towards the bottom of the page in front of you.
Got it, thanks.
Lord Dunedin refers to propositions that have been stated in previously decided cases, and the proposition relevant to the instant case regarding a penalty clause is that the essence of a penalty is a payment of money stipulated as interorum of the offending party. The essence of liquidated damages is a genuine covenanted pre-estimate of damage, and as I'm sure your ladyship is aware, this is indicating that a penalty clause is designed to, it could be said, frighten a consumer into not taking a particular course of action, for example, leaving their car in the car park for more than the 6 days. And clearly the appellant's case today is not one where liquidated damages would apply, as £500 cannot be reasonably said to be a genuine covenanted pre-estimate of the damages suffered. That is a representation of the amount of financial loss allegedly suffered by PCP Limited. Because the appellant was charged £50 per day as well as the usual parking tariff, so therefore PCP Limited didn't actually suffer any financial loss whatsoever, because they will have still been continuing to receive the usual daily parking tariff from the appellant. And if I can again refer you to the case of Dunlop at page 87, paragraph 3, which is on Orange tab 10. The judgment states it will be held to be a penalty if the sum stipulated for is extravagant and unconscionable in amount in comparison with the greatest loss that could have conceivably be proved to have followed from the breach. And at paragraph 4, it will be held to be a penalty if the breach consists only in not paying a sum of money, and the sum stipulated is a sum greater than the sum which ought to have been paid. So your ladyship, I submit that the fee of £50 per day is somewhat extravagant in relation to the usual daily tariff for parking. Unfortunately, we do not have in the facts before us today what the PCP Limited's daily rate for parking actually is. However, as I've stated previously, we must remember that the £50 penalty was in addition to the usual daily parking tariff. This is distinguished from the case of Dunlop, which was found in that case to be a case of liquidated damages.
Okay. You're going to have to wind up now.
Thank you, Your Ladyship, for reminding me of the time. If you require any further consideration of my submissions before making your judgment today, may I respectfully refer you to Schedule 2 of the UTCCR 1999, which provides an indicative and non-exhaustive list of terms which may be regarded as unfair. This is found at Orange tab 11 in the bundle, and particular relevance should be drawn to sections 1B, E and I. I assume Your Ladyship would like time to peruse those.
Yep, I'll consider them when I rise.
Thank you. Your Ladyship, in conclusion, it is the appellant's submission that the respondents PCP Limited are not entitled in law to exempt their liability for destroying the appellant's car through their negligence in omitting to maintain the concrete pillars in the car park. It is the appellant's further submission that the charge of £500 relates to a penalty charge for leaving the vehicle in the car park for more than the stipulated 6 days, and as such, the clause is not binding on the consumer. Your Ladyship, that now concludes my submission, unless I can assist you any further.
No, thank you. I'd just like to check the skeleton argument. You can be seated, it's fine. Ms Platt, the skeleton argument on behalf of the appellant, you're asking me to consider that when I rise, are you?
Sorry.
The skeleton argument contained within the bundle, you're asking me to take that into account when I rise, are you?
Yes, Your Ladyship.
Yeah, okay, and that's on behalf of both of you, covers both the submissions.
It does, Your Ladyship.
All right, thank you. Won't be a minute, Miss Rutherford. Thank you. Ready to hear from you now.
Thank you, Your Ladyship. I have here the respondent's bundle, complete with the skeleton argument at the beginning.
Right, thank you. Right, if you'd like to begin.
Good afternoon, Your Ladyship. I should be dealing with the first ground of appeal in this matter, that is the question of contractual incorporation, and it shall be submitted that the decision at first instance of Mr Justice Jones was the correct decision. In support of my argument today, I would like to make 4 submissions if there is time to do so. The first of these is that the terms and conditions in question are incorporated via a course of dealing, and that secondly, in any event, there is incorporation by notice. Thirdly, I should like to argue that the terms and conditions imposed by the respondent were not so onerous or unusual in the particular context so as to require a degree of notice beyond that which was given. And finally, I should like to make a policy argument that to allow subjective factors such as the unconscionable or onerous nature of a term to have a bearing on the question of contractual incorporation itself would be potentially to undermine the fundamental principle of certainty in contract law. May I proceed with my first submission, Your Lady?
Yeah, just give me a minute to catch up. Right, far away.
As regards the issue of whether there was a course of dealings between the appellant and the respondent, as we have heard from counsel for the appellants, the case law has established that contractual incorporation can occur via a course of dealings between 2 parties, but the question falls down to whether there is sufficient regularity or consistency in the dealings. If I can refer Your Ladyship to the first tab of the bundle,
Yeah.
to an extract from the case of Hollier and Rambler Motors Limited, which is found in the second volume of the Queen's Bench Division of 1972, starting at page 71. Would
It's a
your
head note.
ladyship like a brief summary of the facts of that
Yeah,
case?
I think you'll need to, because there's no head note here, is there?
Yeah.
Right, Hollier at 76.
In that case, the claimant brought an action for damages against the defendant garage after his car was damaged in a fire there. The defendant sought to rely on an exclusion clause excluding liability for damage to vehicles caused by fire. The defendant tried to argue that a course of dealings was established because 3 or 4 times previously in the past 5 years the claimant had parked his car in that garage, but the Court of Appeal said that 3 or 4 dealings over a course of 5 years, which didn't quite even amount to 1 dealing per year, was insufficient to amount to a course of dealings. I illustrate this case because I understand that that falls the other side of what I'm trying to argue, that there is sufficient frequency and regularity to amount to a course of dealings. But I refer to the case to demonstrate that there is no hard and fast rule as what regards the number of dealings which are sufficient to establish contractual incorporation. My learned friends rely on the Hardwick Game Farm case, in which a course of dealings of, say, 3 or 4 dealings per month over a number of years was sufficient. And on the facts of this case, the appellant had parked his car in the car park on 10 occasions over the previous year. Now this amounts to a course of dealings of almost once per month. It is submitted on behalf of the respondent that this is a course of dealings much closer in frequency to the Hardwick Game Farm case than it is to the Motors case, in which frequency was not established. It is also submitted that this is a course of conduct which would likely have continued had the accident not occurred. It is therefore requested that your ladyship uses her discretion and finds that the appellant entered a contract with the respondent on 10 different occasions in the space of the previous 12 months, and that this places the present scenario on the side of a course of dealings having been established.
Okay, thank you.
If possible, I'd like to move on to my second submission, which is that in the alternative, if your ladyship does not find that there is sufficient regularity to amount to a course of dealings, that the terms and conditions in question were incorporated by notice in this
Okay.
particular instance. If I can refer your ladyship to tab 2 of the bundle, to an extract from Halsbury's on contract law.
Right, let's have a look. Okay.
At paragraph 391 to the highlighted section. To be effective, an exemption clause must, as a general rule, be incorporated in the contract at the time when the contract is made, and it is insufficient if the clause is put forward at a later stage. And then the second requirement is over the page, to which my learned friends have already referred, that reasonable notice of the clause must be given to the other party in order that they can be held to be bound by the clause. I would like to deal with each of these requirements separately.
Okay, I'd also like you to address me on when you say this contract came into effect, the mechanism of how that came into effect. Okay.
Indeed, the point of formation.
Yeah.
And that is the first requirement laid out in Halsbury's as to when it is made. And the case of Thornton and Shoe Lane is relevant here, to which counsel for the appellants have referred, and that is at tab 3 of the bundle.
Yeah.
And if I may refer your ladyship in particular to the highlighted section of Lord Denning's judgment
Yeah.
at paragraph D. The customer pays his money and gets a ticket. He cannot refuse it. He cannot get his money back. He goes on to say, he was committed at the very moment when he put his money into the machine. The contract was concluded at that time. It can be translated into offer and acceptance in this way. The offer is made when the proprietor of the machine holds it out as being ready to receive the money. The acceptance takes place when the customer puts his money into the slot. The customer is bound by those terms so long as they are sufficiently brought to his notice beforehand, but not otherwise. He is not bound by the terms printed on the ticket if they differ from the notice, because the ticket comes too late. The contract has already been made. It is submitted here that that case is distinguishable from the facts before us, on the ground that at the point at which the appellant entered the car park, he had already passed a large sign stating that the parking was subject to terms and conditions. And it is my submission that the contract was formed at the point at which the ticket was taken from the machine. It is not clear from the facts whether at this point there was a fee to pay or whether the fee comes later. But it is submitted that entry to the car park itself, passing the sign, is not the point at which it was made. The point at which it was informed is when the ticket comes from the machine. The effect of this, it is submitted, is that Lord Denning's objection does not apply to the present facts because the contract was not being altered by the words printed on the ticket, but those words were already incorporated into the contract by virtue of the large sign outside the car park, which the appellant had already passed. And if I can now move on to addressing the question of reasonable notice, it is accepted that if reasonable steps have been taken to bring the terms to the attention of the other party, that party may be bound by those terms whether or not that party has read the terms or read the document which contains the terms. If I may refer your ladyship to tab 4 of the bundle, to the quite famous case of Interphoto and Stiletto.
Yeah.
Would your ladyship like a summary of the facts?
No, that's not. I can see from the head note here.
If I may refer your ladyship to Lord Bingham's judgment, page 440.
Yeah.
Lord Bingham refers heavily to a 19th century decision of Parker and South Eastern Railway. In which it was held that the question was whether the railway company did what was reasonably sufficient to bring a clause excluding liability to the plaintiff's notice. And if I can refer you to the judgment of Lord Justice Mellish, where he states, the railway company, as it seems to me, must be entitled to make some assumptions respecting the person who deposits luggage with them. I think they are entitled to assume that he can read and that he understands the English language and that he pays such attention to what he is about as may be reasonably expected from a person in such a transaction as that of depositing luggage in a cloakroom. The railway company must, however, take mankind as they find them, and if what they do is sufficient to inform people in general that the ticket contains conditions, I think that a particular plaintiff ought not to be in a better position than other persons on account of his exceptional ignorance or stupidity or carelessness.
So is the respondent's contention that it's reasonable to have to drive up to the 3rd floor necessarily to understand what the terms were that are being entered into?
It is submitted first that there was a big notice. The first step which was taken by the respondent was the large notice outside the car park.
At the entrance, yeah.
At the entrance. Secondly, there was the statement on the ticket. As many of us know, when we get train tickets, there are references to terms and conditions to be found on a website or on another document. That does not of itself mean that those terms are not incorporated or that reasonable steps were not taken.
Appreciate that.
And then that ticket itself refers to the notice board. It's not clear whether the ticket refers to the location of the notice board.
No.
And the question is whether what the respondent did was reasonably sufficient, not what the appellant did to inform himself. But it is submitted that the reference on the ticket makes potential customers aware that there is a notice board.
Up on the 3rd floor. That's where it is, isn't it?
The
Am I
notice
right?
board itself.
That's what was in the judgment, wasn't it?
Floor.
Yeah, so the ticket says drive up to the 3rd floor to read the T's and C's.
And it is submitted that those would be sufficiently reasonable steps. There might be a particular reason why the notice board is on the 3rd floor. Perhaps the 3rd floor happens to be the busiest floor of the car park, the court is unaware of the layout of the particular car park.
Speculation, though, Miss
Unfortunately.
Rutherford. Speculation. Okay, thank you. So, do you want to carry on then?
Thank you. To sum up my first two submissions, first, it is submitted that there is sufficient regularity and consistency between the dealings of the parties to amount to a course of dealings, and if your ladyship does not so agree, that the relevant requirements for incorporation by notice have been established on the facts, distinguishing the case of Thornton but applying the railway case of Parker.
Okay.
Thirdly, it is submitted that this particular term, or these terms in this contract, were not so onerous or unusual in this context, the context of car parking, as to require a degree of notice beyond that which was in fact given. There are many references in the case law, such as the case of Interphoto itself, by Lord Justice Bingham, and this is at tab 5 of the bundle. That where a clause, the more unreasonable a clause is, the greater notice which must be given on it, and referring to the case of Spurling and Bradshaw, that some clauses should be printed in red ink on the face of the document with a red hand pointing to it, because they are of such an extortionate nature. It is submitted that in this case, the type of clause which is found is a type which would be expected in the context of car parking.
Now, which one are we talking about?
Both of them. Firstly, the exclusion of liability for damage, and secondly, the imposition of a fee. The Interphoto case is a very unusual case, which involved a clause which did not relate directly to the kind of clause one would expect in the context of photographic transparencies and lending. And to illustrate this point, if I may refer your ladyship to the case of AEG Limited and Logic Resource, which is found in the commercial law cases of 1996, starting at page 625, which is the 6th tab of the bundle. Lord Hobhouse in this case dissents on the issue of incorporation. He states, the Interphoto case involved an extortionate clause which did not relate directly to the expected rights and obligations of the parties. In the Shoe Lane parking case, it related to personal injuries and the state of the premises, and not to the subject matter of the car parking contract, which would, in the view of the Court of Appeal, have been concerned with damage to property. In my judgment, it is necessary to consider the type of clause, and only if it is a type of clause which is not to be expected will be found in the conditions, and then to go on to question its incorporation.
1 minute.
Thank you. To sum up then, it is submitted that the particular type of clause the respondent was attempting to incorporate are standard clauses in the context of car parking. By contrast, the Interphoto case, we had a very unusual clause in which, to use Lord Bingham's words, a venial period of delay led to inordinate liability of almost £4,000. We're dealing with a much smaller sum.
I understand the distinction you're seeking to draw there.
Finally, I'd just like to make the point that to allow subjective factors such as unconscionability and the onerous nature of a clause to affect the question of incorporation itself would serve to undermine the fundamental principle of certainty in contract. And Lord Hobhouse, in fact, does go on to make this point, which I've also highlighted. A wide range of clauses are commonly incorporated into contracts by general words. If it is to be the policy of English law that in every case those clauses are to be gone through with a tooth comb to see whether they were entirely usual and entirely desirable, then one is completely distorting the contractual relationship between the parties and the ordinary mechanisms of making contracts. It will introduce uncertainty into the law of contract.
That's a matter that you flagged up in your skeleton argument, so I can consider that further at that stage.
Thank you, my lady.
Does that conclude your submissions?
That does conclude my
Thank
submissions. My learned junior shall now address
Okay.
the board.
Just give me 1 minute, Ms McAllister. check where I've got to so far. Okay, afternoon, Ms McAllister. Can I just check with you for the avoidance of doubt beforehand, before you proceed? The finding in the judgment of the lower court that the pillars had been negligently maintained by PCP Limited, that's not subject of any challenge. Okay.
Good afternoon, Your Ladyship. My name is Orla McAllister and I am the Junior Counsel for the Respondent in this matter. I'll be addressing the second ground of appeal, which is, even if the terms were incorporated, they were not effective to exclude PCP Limited's liability or to entitle it to a charge of £50 per day for late collection. Under this ground, I will be making 3 submissions, the first of which is that the clause excluding the respondent's liability for property damage and economic loss is not an unfair term under the Unfair Contract Terms Act 1997, which I will refer to as UCTA from now on, or for the purposes of the Unfair Terms in Consumer Contracts Regulations 1999, which I will refer to as the 1999 regulations from now on. My second submission is that the term which imposes a fee of up to £50 per day for late collection is properly construed a liquidated damages clause and not a penalty clause. And then my third and final submission, which is that there are strong policy reasons against striking down such clauses as penalty clauses. May I begin with my first submission?
Yes, if you would.
If I could refer you to the first tab of the bundle there. So there's a division in the middle.
Right, give me a second. That's the orange?
Yeah.
Yeah. Okay, got it.
Here at section 2 of UCTA subsection 2, it states that in the case of loss or damage, a person cannot so exclude or restrict his liability for negligence except so far as the term or notice satisfies the requirement of reasonableness. UCTA is subjecting clauses which exclude liability and negligence for other sorts of losses apart from death and personal injury, so property damage and pure economic loss, to a requirement of reasonableness.
Yeah.
Section 11, subsection 1, which is found over the page, sets out how reasonableness should be tested. It states that the term shall be fair and reasonable one to be included, having regard to the circumstances which were or reasonably have been known to the parties when the contract was made. In decisions of reasonableness, regard must be had to the factors in Schedule 2 of the Act, which is also contained in the bundle over the page. Here it states that at subsection A, the strength of bargaining positions of the parties relative to each other, taken into account, amongst other things, alternative means by which customers' requirements have been met. Subsection B, which states, in accepting it, had an opportunity of entering into a similar contract with other persons, but without having a similar term. Subsection C, which states that whether the customer knew or ought reasonably to have known of the existence and the extent of the term, having regard, amongst other things, to any custom of the trade or any previous course of dealing between the parties, and subsection D, which states that compliance with the condition would be practicable. Here, regard has to be paid to such things as the availability of insurance against excluded liability, whether the claimant knew or ought to have known about the term, whether the term is clearly worded, and whether the term is standard or usual within the relevant market.
Right, and where are you getting that from?
That's just a summary of...
That's your
Yeah,
summary,
yeah.
right, yeah. Okay, so,
and if I could refer you to tab 2 of the bundle, which is the case of Monarch Airlines and London
Yeah.
Luton Airport Limited, found in the
that's it.
commercial law cases of 1997, starting at page 689.
just give me a brief overview of this one.
Here, the plaintiff sued the defendant for negligence because their plane was damaged on the airport runway. But it was found that the clause which excluded the airport's negligence liability for damage to planes on takeoff was held to be reasonable under Section 11 of UCTA and their test of reasonableness, principally because the airline knew about the clause and accepted it without complaint. Its meaning was clear, and most importantly, both parties and their insurance arrangements on the basis that the airport was not liable for negligent damage.
They knew in advance of entering into the contract, you say?
Yeah.
Okay.
It is submitted on the facts then that the appellant may have known, or at least ought to have known, about the exclusion. His car surely would have been insured heavily. The fact that it was quite expensive motor, also the fact that insurance to drive a car is compulsory in this country. It is also submitted that these terms are standard in this industry, as everyone who uses car parks anticipates that the car park owner is not liable for damage to their vehicles.
Using some judicial knowledge here, I've seen it excluding third-party damage. Are you saying it's usual and to be expected, a blanket exclusion, including that of negligence of the owners of the car park?
The owners of the car park,
i.e. the respondents in this case.
the respondents in this case would not have to, the fact that the appellant would have insurance for any damage done to their car means that the respondent would not have to take any sort of action to prevent that car from being damaged in any sort of way.
Most insurance policies have an excess, don't they?
Yes, but that insurance policy is between the appellant and their insurance rather than the respondent and the insurance company.
Okay, so if you'd like to continue.
Yes, the appellants have argued that under the 1999 regulations that the exclusion clause is unfair. However, if I could direct you to tab 3 of the bundle, to regulation 8 subsection 1.
Yep, got it.
Which states that an unfair term in a contract concluded with a consumer by a seller or supplier shall not be binding on the consumer. Regulation 5, subsection 1, which is over the page, states that a term shall be regarded as unfair if, contrary to the requirement of good faith, it causes a significant imbalance to the parties' rights and obligations arising under the contract to the detriment of the consumer.
Yeah.
There's also a list of potentially unfair terms in Schedule 2.
Yeah.
This list is non-exhaustive, and it is important to highlight that just because a term may appear on this list does not mean that it's automatically unfair.
No, I appreciate that.
And these 1999 regulations have been applied in case law, particularly to the Director of Fair Trading and First National Bank in the House of Lords 2001, starting at page 52. The facts of this case are
Where's that in the bundle?
it is at bundle tab 4.
Yeah, just looking at it. Yeah, got it.
The facts of this case are irrelevant at the present moment to the facts of the case before us, and it's quite a difficult case. However, the decision of Lord Millett puts forth quite an important test, which is to ask that if a term were drawn to his attention, the consumer would be likely to be surprised by it. In other words,
I can see that. Yeah.
In other words, he is looking at the reasonable expectations held by the consumer as regards the contract. He's not looking at whether or not the term was drawn to the consumer's attention, and the focus is not on procedural fairness. It is submitted that on the facts that this type of term would be expected. Most car parks display similar terms as regards loss and damage, and it is a well-known and standard term in this particular industry, similar to the factors of UCTA. Finally, the appellants have referred to the Occupiers Liability Act 1957. This applies only to visitors. In fact, at the time of the damage, which was the 16th day of occupation, the appellant is arguably a trespasser or non-visitor, and therefore the Occupiers Liability Act 1984 applies. which is found at tab 5, which states that where a person owes a duty by virtue of this section, he does not, by reason of any breach of duty, incur any liability in respect of any loss.
Why is he a trespasser? Sorry to interrupt you. Why is he a trespasser? I don't understand.
It is submitted that because he had only paid to be a visitor of that car park as long as he had actually paid for. After that time, he was a trespasser on the premises, as he had no right to be there. He hadn't paid for to be there.
Right.
As he was only allowed 6 days to stay there, and he actually stayed for an extended period of 16 days.
But as I understand it, setting aside the additional fee, he's still charged for every day he's there, including the days after his initial 15 days, 10 days.
Yeah, he has to pay for it, but he has not yet paid for it
So he's
at the
charged
time
for
that
it.
he had occupied the space.
Okay.
I would like to begin my second submission,
Yeah, sure.
and that is that the term which imposes a fee of up to £15 per day for late collection is properly construed a liquidated damages clause and not a penalty clause.
Okay, talk me through that.
A liquidated damages clause is if there is a breach of contract, one party would have to pay for the breach that they would have to pay for the breach. In this case, it is argued that the appellant has breached the car parking contract by waiting 16 days to pick up his car when he initially only paid for 6, and therefore he must have to pay a fee specified by the respondent.
It's right that he's already paying his parking fee, so this is an additional sum.
Yes.
So what basis is that sum reached? How is that quantified?
He's paid for the 6
£50
days.
a day, yeah.
And he stayed for 10 extra days.
Yeah.
So that's 10 extra days that spot has been taken up. Further to that, in the case of Murray and Leisure Play, they actually talk about the test of Dunlop, which was put forth by the appellants.
Yeah.
In this, he supported a recasting of the Dunlop test. This test of genuine pre-estimate of loss test, and he wanted it done in more modern terms to look at was the predominant function of the clause in question to deter a party from breaking the contract or to compensate the innocent party for the breach. In this case, it was for the breach of contract being compensated rather than to deter them from leaving his car for that long. It is submitted on the facts that the purpose of the £50 per day fee is to compensate and not to deter, and is never referred to as a penalty or as a fine. The appellants have also argued that the fee of up to £50 per day is extravagant and unconscionable in amount in comparison with the greatest loss that could have conceivably be proved to have followed from the breach, so it should be struck down as a penalty clause. It is accepted that this case was a House of Lords case. However, it is nearly 100 years old, and more contemporary authorities on the matter seem to be willing to find it that the clause is not is a penalty clause, as I've talked before. Lord Justice Clark also stated that the onus is on the parties alleging that the clause is a penalty clause to prove that it is a penalty clause,
Where's that come from?
and that is at tab 6. Paragraph 7, in which he states that it is important to have in mind that the onus of showing that the clause 17 is a penalty was on the respondent.
Yeah.
Yeah. There is also application of the 1999 regulations here. In Schedule 2, subsection 1, subsection E, any term which requires any customer who fails to fulfil his obligation to pay a disproportionately high sum in compensation is prima facie considered unfair. It is submitted that here we have a fee of up to £50 per day, and a total of £500 in total is hardly extortionate. May I proceed with my third submission?
Yeah, go ahead.
My third and final submission is that there are strong policy reasons against striking down such clauses as penalty clauses. Liquidated damage clauses fulfil an important function in contract law, so we should be reluctant to strike them down as penalty clauses. They are generally viewed as a good thing because if the parties can estimate in advance the loss that they will suffer as a result of a breach and insert such a clause, they will save themselves time and money by having to go to court. This saves court time, prevents litigation, and it also allows each party to know in advance exactly how much they will have to pay for breaching the contract and to prevent disputes. Further to that, there has also been expansion in the last decade of the circumstances in which a party can recover non-compensatory damages. This suggests that the law is becoming increasingly comfortable with the idea that a party can recover more than he's lost. If I can't assist the court any further, that's the end of my submissions.
Okay, thank you. Just wait there a minute. I flagged up an issue earlier on. I'm assuming it's not a matter of contention between the parties. There's no suggestion that there were any bookings online. Am I right?
As far as we know, the facts that we were given do not suggest that there was a booking made online.
Okay. Right, thank you, Ms. McAllister.
Thank you very much.
All right then, so Ms. Platt, I'll give you opportunity if you wish to do so to make any very brief points in reply.
Thank you, Your Ladyship. Firstly, as the respondents have been referring to cases which refer to contracts between business to business, it's the appellant's submission would like to point out that the bargaining powers of the parties are different from business to business in the present case. The respondents also refer to Hollier and Rambler, which deals with 3 to 4 dealings over 5 years, which was found to be insufficient as a course of dealing.
That was a point already made.
It was, yes. As we've already stated in Hardwick and SAPPA, it was found that 100 dealings was sufficient, and it is the appellant's further submission that 10 dealings is not, as in Hollier and Rambler. The respondents state that the terms were also incorporated by notice, and that to be effective, it is incorporated at the time that the contract was made, or if reasonable notice is given. The respondent stated that the contract was made at entry of the car park, and when the ticket was taken, we are in agreement with that. But the respondents seek to convince you that reasonable notice was given due to a sign at the entrance. However, the appellant would like to remind you that the notice at the entrance did not in fact state the conditions. As your ladyship has already questioned, is it reasonable for the appellant to drive onto the 3rd floor of the car park, and further, if he did not agree to those terms, have to leave after already obtaining a ticket? As the respondents has seek to convince you as to the reasons for the terms and conditions being on the 3rd floor, we must remind the court that we must not speculate on that point. The respondents state that the terms were not onerous, therefore sufficient notice need not be given. However, Lord Denning stated in J. Sperling Limited in Bradshaw on page 466 that in the judgment that the term does not call for such exceptional treatment, especially when it is construed, as it should be, subject to the proviso that it only applies when the warehouseman is carrying out his contract and not when he is deviating from it or breaking it. Therefore, it is the appellant's submission that there was an implied term to take reasonable care and that the respondents negligently maintained the pillars, which is deviating from the contract. The respondents have also admitted negligently maintaining the pillars, and therefore they are liable under section 1, subsection 1 of UCTA 1977. The respondents have a duty of care under UCTA 1977, and the appellants believe that this has been established by the Junior Counsel in her submissions. OLA 1957 states that the appellant is a bona fide visitor. Therefore, it is the appellant's submission that the appellant is not a trespasser as stated by the respondent under OLA 1984. It is not clear from the facts when he paid the parking tariff or when the payment was due. He was still a visitor over the 6 days, as nothing restricted him from staying longer than 6 days. The appellant still had to pay the daily rate for the extra 10 days, so the respondents have suffered no loss by the appellant staying on the car park for longer, and the £50 is in addition to the usual daily tariff.
Now, Ms Platt, you're in danger of repeating points that you've made in your submission.
Your Ladyship. It is the appellant's final submission, therefore, that the £500 is extortionate and cannot be said to be reasonable.
Thank you, Ms Platt.
Thank you.
Right, take a seat. Right, thank you everyone. Thank you for your learned submissions. I'm going to rise now and see if I can reach my decision briefly. So if you could just return to your waiting rooms, I'll let you know when I need you. Okay, thank you.
Thank you.
So I'll just very, very briefly give you the judgment, then I'll give you the decision on the Moot Champions, and then I'll briefly run you through why, okay? Yeah, so give you some pointers. Judgment, I find for the appellants. I find that the clause purporting to exclude liability for the damage caused was not incorporated into the contract. I don't think that Mr. Smith's visiting on 10 occasions is sufficient to amount to a course of dealings. In the circumstances, I don't find that reasonable notice has been given, and it's a particular concern to me when I make that finding, the placing and the sign and the size of the clause exempting liability. In any event, by virtue of UCTA, I find that it wasn't a reasonable clause. Further, I'm satisfied that the fee of £500 amounts to a penalty clause and therefore cannot be relied upon. So I find for the appellants. Now, turning to the moot. Observations to make are blown away by how good you lot are. Honestly, I've got to say, honestly, you should all be really, really proud of yourselves, because there is no way when I was at your stage I could ever have stood up and presented arguments as coherently as you lot did. So you should be proud of them all. Next thing to say is, honestly, it's a whisker. So I am going to give it, but I mean by a tiny whisker, no offence to those who have won, to Miss Platt and Miss Boardman. But and the main reason for that is you worked slightly more coherently as a team, but just, as I say, slightly more. So please don't be deterred, because you were great. And so moving through various bits and pieces, in terms of the bundles, Really good skeleton arguments. I preferred your skeleton argument, actually. I like the way you laid it out, but yours was, so have a look at how they did theirs if you've not already seen it. But you all got the idea, which is to key up the main points for me. What you should always do when you start one of these, when you're doing submissions, is take me to your skeleton, though. Take me to your skeleton and work through it, okay? And then that way, none of you gave me an outline of what the whole submission was going to be on behalf of both of you. So make sure you do that. So, of course, you're dealing with your own stuff, but you want to flag up as leading what's coming, so I know and I can think it through. So there's that to bear in mind. This is just a little housekeeping note that I didn't take account of, but just so that you guys know for the future. Don't stick them in these, because what your judge will always do is write. So what I do as I go along is I'm marking up where you've taken me to, and I'm kind of starring up and all the rest of it. And when you've got them in these folders, can't do that, so I have to fish them out. Okay, but as I say, that's not a matter that I took into account. Time management, it's harder because you had more to deal with. So, you know, that's why it's quite a difficult one. But you were slightly better bang on in terms of your time, although, you know, I was asking lots of questions. You could all think on your feet really well. And although I said to you speculation, that's a bit hard for you because actually you didn't have, and if this were for real, you would have all those facts at your disposal. So, you know, you were having to make them up as you go along a little bit. But you will find, if it's not in the judgment, don't ever advance because you'll get pulled up for it. But at least you were all attempting really well to think on your feet. All of you, ever so confident, your manner was all appropriate, you were polite, you remembered how to address a judge, which is something that I in the past have forgotten, and people use all kinds of strange descriptions for judges. And you all kept your nerve, which was brilliant. So, I think, oh yes, in terms of authorities, again, all of you addressed me on the authorities. You had the facts at your fingertips when I needed it. I would say, for you, Mr. McAllister, I think you had the hardest of the lot. Is that how you felt in terms of that argument?
Yeah.
Because, you know, talking about, and for both of you, you couldn't really provide me an explanation as to why it's on the third floor and all those different things. So that was hard, and you did your best to deal with that, so I was impressed. Okay, is there anything, I know you've got to go off to a class, but is there anything you four want to ask me? Because I've been doing all the talking, haven't I, as to how this has gone, but... No, but you know what, if you think of anything, you can always ask Emma, and she can...
I would just like to thank you for being our judge today.
Oh, it's been a pleasure. It's been lovely seeing you all, and it's great seeing such impressive young women working their way up through the system. So good luck to you all. You've been brilliant.
I'm glad you said that because I was also very pleased you had a lady judge.
There's plenty of us
nice
around, and now's an opportunity to say, you know, as you go through your career, keep your eyes out for doing fee paid, which is, you know, the part-time judicial appointments. You can do them at a fairly early stage, and it's great. I would highly recommend it. And finally, if any of you would like to come and do a shadowing day with me, then that's the least that you deserve. Obviously, you may not wish to take me up on it, but in the employment tribunal. So, and arrangements could be made through you. And I'd be more than happy to have a chat with any of you. We'd arrange you come and have lunch with me or whatever. All right?
Thank you.
Okay.
Thank you very much. Very much. What a fantastic bonus prize there for the judge. Thank you very much for that.
Yeah, no, and I mean it. So,
So that's a fantastic bonus prize for all 4 finalists. So I think you should be...
They well deserve it. They
Snap
do.
our hands off. Yeah, because it's a fantastic opportunity for you to have that. Absolutely well done. The quality of this I knew was going to be exceptionally high. I am so proud of all 4 of you.
Great.
There is a temporary certificate in here, but we'll get you a proper nice one. We have a certificate each. I'm not sure which one's which. Yellow's this side. So well done, runners up, and you will have £25 each coming your way as well. As the judge said, please don't be deterred by that, because it was when I went through to see the judge, she did say, "Can I call it a tanner?" And I said, "Unfortunately, not."
Yeah, I
so
would have
that's
done if I
how
could have
close
done.
it was.
I would have done.
Okay, and it was with great pleasure that I award you with the trophy. Your names will be engraved on there. So very, very well done. Very impressive.